And then we do. Okay, so I'm gonna step over here. This. And then I'm gonna ask the folks that have joined us virtually, if someone can turn their camera on and give us a thumbs up that they can hear me. Someone, anyone? Someone?
Yes.
Great, thank you so much. Super appreciate that. Okay. Okay. So first I want to thank everybody for joining us. We do have a sign-in sheet for folks who are seeking MCLEs. That'll be here very shortly. Make sure that you sign that before you leave the room. And I'm actually really excited to have this conversation. And I use that term very intentionally. Because what we're hoping to do is really have a conversation. The idea is that we don't get many opportunities to really work through and think about, and not necessarily resolve, but have an opportunity to brainstorm when there are ethical considerations, ethical concerns, legal concerns, as we all walk through this work. And this is not exclusively for attorneys. In fact, one of our panelists is an attorney and a tribal leader, and she'll be kind of talking through that lens of those dual roles. And then we have another panelist who also has dual roles, who'll be talking through some of these issues, again, through those dual roles. So that is the goal for this afternoon. So I am Kimberly Cluff. I am the legal director at CTFC, and I'm going to do a very brief introduction and pass it over to my co-panelists to introduce themselves, and then we'll get started back with me. So I come to practicing Indian law. I went to law school to do Indian law. I did as many folks in California. I worked at California Indian Legal Services at the beginning of my career. And certainly some of my reflections today are based on my experience at CILS. And then I had an opportunity to be in private practice, and then had an opportunity to serve as in-house general counsel for a tribe. And now I'm at CTFC. So I've worn multiple hats through my experience in being able to be an advocate for tribal rights and interests. And that has provided me both a really amazing career and an opportunity to see some of the ethical dilemmas and the challenges that come with that work. So with that, I'm going to hand it to Mark.
Thank you. Thank you, Kimberly, and thank you to the coalition for inviting me to be on this panel. So I'm the directing attorney of the Escondido Office of California Indian Legal Services, but as Kimberly noted, I also have another job, two jobs, and that is as the chief judge for the Paula Band of Indians, Mission Indians, and the chief judge for the Chemehuevi Indian tribe, which is at Lake Havasu in San Bernardino County. So I've been doing this work now for a little over 13 years, and the first person who ever hired me to do anything related to tribal law is sitting in this room. It's Joanne Willis-Snooden, who hired me to be a law clerk at CILS in, I think, 2004. And then the next person, what's that? Well, we're in it together, Joanne. So,
Ethical dilemma number one.
and then the first person to hire me as an attorney doing tribal law is Judge Lamaista, who is here too. So, yeah, I guess we're all aging together, but getting better and doing the best we can for tribes.
Hilly, everyone. My name is Janet K. Bill. I'm the chairperson for the Picayune Rancheria, the Chukchansi Indians. As Kimberly also mentioned, I am an attorney with the State Bar of California. I graduated from ASU's Indian Legal Program there right out of law school. I had the opportunity to work with Erica, who's in the room, at Berkey Williams, transitioning from being a law student to a practicing attorney. I took a break and became a tribal leader for a little bit. So I'm just really excited to share with you just my experience in both roles, and hopefully kind of either explain the challenges that I've had and how we can overcome them together. So I'll pass it back over to you.
Thank you. And talk about feeling old. Chairwoman Bill is a law clerk.
Oh my God.
Mine, only a few years ago, so yeah. It is a very small community of people, and actually that raises, one of the first things that I want to talk about in terms of the way that we navigate a very small community of people and the ethical concerns that that brings up. So that is one area that, for me, as an advocate in any country, has been a challenge. So for example, there's folks in the room who think I've ever been on the opposite side of, but very well could be people who are dear friends, who are former colleagues, and finding them on the opposite side of controversy, on the opposite side of a case, can really be a challenge. And what that means is that we have put on our professional hats and we make sure that we walk into that courtroom or we walk into that meeting knowing that this is not personal, that this is professional. And I say that with some aplomb, like it's really easy. It is absolutely not easy. And it's something that I talk to law clerks about on a regular basis, to be sure that they understand that we have to maintain that line between our professional role and those personal relationships. I know for a fact that that carries over to tribal leaders, for example, and they have to make extremely difficult decisions. In fact, Chairman Smith mentioned that earlier, right? So on the last panel, Chairman Smith mentioned in somewhat of a humorous way that when his family comes to him, he gets to say, go talk to the judge. It's not my problem anymore. And he said that with some humor, but that is very truthful. And I've had that experience on repeated occasions with tribal leaders who find themselves in difficult positions, for example, with tribal members who are relatives and need, for example, an intervention. I will say one thing that a person who I consider a mentor said to me once that has been tremendously helpful, even working for a well-resourced tribe. One thing that has helped buffet challenges around personal issues and personal needs is when you have money that's coming through the door, that funding that's coming through the door for a tribe that is grant funding as opposed to general funds of the tribe. And you don't have to go to the tribal population to say we need to spend general funds, and the tribal population may say, hey, you're taking $1 out of my pocket to solve somebody else's problem, and I don't support that. But if you're spending, for example, a SAMHSA grant to help tribal members receive services that they need, that doesn't raise that specter of kind of the public process in a tribal council meeting of why are we spending funds to send a tribal member to treatment, for example. And so when I was working as an in-house attorney, even for a very well-resourced tribe, found ourselves looking to find resources that were not going to trigger that question about, you know, what's mine and what's yours in a public way within the tribal population. So that was one that I found very helpful in terms of kind of a thinking about practice. When we were talking earlier and preparing for the panel, the other kind of ethical practice tip that for me has been really helpful is that when I have found myself facing a uh-oh moment, and I'm going to just give a hypothetical. I'm sitting in my office, it's 8 o'clock at night, and a tribal leader calls and says, I need help with something. Of course, I want to be responsive to that tribal leader, and you never want to say no to the boss. And yet I know that this is probably an area that's outside the purview of general counsel for the tribe because my client is not individual members of the council. It is the council as a whole. And in fact, it's actually not the council necessarily, it is the tribe as a whole. And so those situations arise, and finding your kind of safe narrative to say, wow, council member so-and-so, I'm sorry that you are facing that issue. For example, can we reconvene in the morning and bring this to tribal council and see if tribal council wants to have me take on this problem or this work or this issue. And in the in-between time, I have an opportunity to kind of collect myself and, if necessary, call the ethics hotline of the California State Bar. I am a frequent flyer there. Happy to say that. Not because there are particularly so many ethical bridges that I have found, I don't think out of ordinary, but it's really nice to get that perspective of a completely neutral. That goes back all the way to the point that I started with, which is it's a very small community. And so it's not always the situation that I feel I can pick up the phone and call a mentor or a former colleague, because it may be that that's going to touch into the world that they're working in because it is such a small community. So being able to reach out to that kind of neutral third party. Now, the downside of that, I will say, is it takes a lot of explaining to that poor soul on the other end of the California bar ethics hotline to give it kind of, Indian country 101 lesson, right? Because there's always a sense of bewilderment, I will say. Although last time I called, I think I actually got someone who I'd spoken to before, and we got to kind of skip to Indian Law 102, which was really good. Give me a bit of pause, but so that's another, for me, place in which I have built into my practice to be sure that I'm using outside resources whenever possible to help me navigate some of those tricky issues. And then the last point that I wanted to raise, if we have time, and we do have a hard stop at 4:40, right? Hard stop at 4:40. But if we do have time, we also have a video that is about 18 minutes that walks through the next ethical dilemma, I think, in a really, really beautiful and storytelling way, which is doing Indian Child Welfare Act work. It is sometimes really a challenge to say, for example, the rights of the tribe are X to the rights of the parent, and you can fill in that blank. They are superior to, they are equal to. In this situation, they're going to trump. And it has been the situation that I've had to work with a parents' counsel, look at a parent and say, we know, we hear you, that you want your child to go to your boyfriend's mom, but the tribe is making a decision against your wishes that the child's going to go to this other home, and in every situation it has been to a tribal relative. And that's not an easy directive. You look at that parent, I'm a parent myself, and to think about that dynamic, that's not always easy. And I have definitely gone into courtroom bathrooms and had a little cry and said that was really hard. But the reality is that that is what the Indian Child Welfare Act says that we need to do. I sometimes use the descriptor that the tribe, and I think other people in the room perhaps have done this as well. The tribe is like a third parent. It's a very easy and concise way to describe the role of the tribe in an Indian Child Welfare Act case. I actually don't know if it's entirely apt or entirely accurate, because I think that it's not quite that. But in talking to parents, in talking to other relatives, to say that the tribe has taken a position that is at odds with the position of your family can be uncomfortable, can be difficult. Now you throw in that perhaps someone within that circle is a tribal leader, and that can get very, very difficult. And I know the right thing to do in that situation, but that doesn't always mean it's the thing that feels good in the moment. And so kind of overcoming that hurdle is something that in those situations, I do find reaching out to former colleagues and just having that moment and saying, wow, that was really hard. That is really helpful. And when you explain that to, say, a bench officer, when you talk to a judge and you say, Your Honor, this is the tribe's position, you get a little bit of side eye, and you get side eye from parents' counsel, and knowing that you're likely going to be up against that parents' counsel next week on a different case, and they're now very, very upset with you, and what's my North Star? Then I find great comfort in going back to the Indian Child Welfare Act and saying, I know the role of the tribe, and the overwhelming best interest for that child is to maintain the connection with the tribe. I know that in the long term, and here in this court hallway, this is hard, but that's the long-term interest of the child, and that's my job. At the end of the day, that's what I was hired to do. So those are just my kind of signposts that, and I'm going to pass it on to Mark to wear a different hat of judge and attorney.
Thank you, Kimberly. So many good points raised in Kimberly's introduction. I'm not quite sure where to begin, but I think a big part of the work we do, which is extremely unique and in a niche field, is relationship building. But it's also important for people who are tribal attorneys and tribal court judges to know when not to have social relationships with people, because you want to protect the integrity and the reputation of the court system. The worst thing somebody could say to me is that the tribal court is biased or somehow stacked against them, that their due process rights were ignored or violated somehow. And I actually learned last week that somebody did say that about me. But it was kind of a unique situation because this particular individual had a judgment entered against her without, it was a default judgment because she never responded to a lawsuit. And tribal law permits default judgments. That would be standard practice in state court as well. But when the tribe tried to enforce my order in state court, and the tribe does have a recognition of tribal court order ordinance, this individual's response was that the tribe said it can do whatever it wants to do because it's the tribe, and that she was discriminated against because she was a non-Indian. But the tribal court order was signed by a non-Indian who held a hearing for this individual, even though tribal law did not require that. So I'm pretty sure that's not going to go anywhere. But another thing that I wanted to bring up, and again, Kimberly touched on this, is that when I go to court, when I go to state court as a CILS attorney representing a tribe, I think we all know, especially after this conference, that parents and minors get court-appointed counsel. And the coalition, one of its great projects, is working on getting court-appointed counsel for tribes, because tribes are the one party that are not guaranteed legal counsel in state court dependency cases. But it does happen sometimes that I am confused with or mistaken for the tribal parent's attorney. And this just happened a couple of weeks ago. And what took me by surprise is that the judge multiple times in one hearing referred to me as mother's attorney. And it's never easy to correct a judge, but you have to kind of put on your charm and your big smile on Zoom and say, well, Your Honor, with all due respect, I represent the tribe in this matter. And while the mother is an enrolled member of the tribe and we intervened in this matter under the provisions of the Indian Child Welfare Act, she has court-appointed counsel. And it's also true that the interests of a tribe and a tribal member parent, or even a non-tribal member parent, can align at different times. And they're really great opportunities, potential opportunities for collaboration and partnership, to argue for active efforts to kind of poke holes in perhaps a flimsy case by the county social service agency. Sometimes, as Kimberly pointed out, you're going to advocate for your client because your client has a difference of opinion with the parent or the parent's attorney. And you have to remind yourself why you're there, what you're there to do in court. You're there to represent the tribe, which is not an individual person. It is a governing body. But another thing that makes it so difficult to sometimes represent tribes and to be a tribal court judge is that tribes are also families and tribes are communities. And you want to be mindful of that. So my approach is, and I try to do this as much as possible in my professional life, but also in my social life, just be respectful of everybody. But every order I make, everything I say in court needs to have some kind of basis in tribal law or in state law if I'm in state court representing the tribe. So I think those are important things to remember. The last thing I'm going to say, and this might sound like a no-brainer for the attorneys in the room, and I think there are many. Technically, you're not supposed to talk to a represented individual without that person's attorney's permission. And I bring that up because, when you get sloppy about that, bad things can happen. And I know I don't want anybody talking to the tribe without my presence or my permission if I represent them in a proceeding. And just to show you how extreme I am about following this rule, which is a legitimate professional rule, but it's also a personal rule. A few months ago, I was invited to a pirate-themed birthday party in Los Angeles. It was a birthday party for a little boy on a case that we've had open for about 5 years. Unfortunately, mom and dad are not in the picture. This child is in a placement, a very good placement. But the tribe is out of state, and the child has a number of traumas from growing up in a household like he did. So his relationship with other children is rather strained. Once in a while, he'll exhibit aggression. But he loves being around grown-ups. He's very articulate. He's very precocious. So the placement was aware of his tendencies towards other children and invited adults because she wanted to make sure that he had a very happy pirate-themed birthday party. So I don't want to hurt anybody's feelings, but I'm not sure that attorneys are the first people on the invitation list to a birthday party for a kid with an open April case. But there were a number of attorneys invited to this particular event. So I reached out to the minor's attorney and I just said, look, I was invited to this party. I think it would be a hoot. I want him to have a good time. And frankly, I'd like to see him. I haven't seen him since COVID. Do you mind if I go? I promise I won't talk to him about active efforts or about, the last minute order or anything like that. And she said, absolutely, go and have a good time. So we went, we had cake, we threw the football around. It was a nice event. But I don't want people doing that with my clients. So I gave her the courtesy that I would expect in return. So I'll pass it on.
Where to begin? I guess the first thing I always like to do is get to know my audience a little bit. So we're going to be a little interactive. How many of you here are in-house counsel for a tribe? How many of you work at a law firm that represents tribes? Wow. How many of you are at other law firms or other legal organizations that help tribes? Look at this table. Raise your hand. Okay. And then how many tribal leaders do we have here? Tribal leader. May I ask you what capacity you work with tribes?
Me?
Yeah.
I work at the university.
Oh, perfect. So for me, I don't know how many tribal leaders are also attorneys in the state of California, so I thought I would mainly gear my comments towards being a tribal leader and how I'd like to see our legal team work with tribal leaders. So one of the things that I've noticed is, one, I've seen a few memos just in that only talk about California state law that is in almost direct contravention to our tribal laws. So one of the things, that should just be a basic thing, and I've had to kick it back. I said, this isn't controlling, this does not pertain to this situation. So that would be one thing that I first start off with. It should always be tribal law first. In my opinion, then you go to federal and if needed, state. So just things like that. Also, I believe it was touched upon too, is who is your client? It's not necessarily the tribal chairperson. It's not necessarily anyone on tribal council. It's the tribe. So really making sure that that is something that you're taking into consideration whenever you bring a legal memo forward to tribal council, because again, you shouldn't be trying to accommodate just one council member's point of view. It should be for the best interest of our tribe. Specifically for ICWA cases. Also, just having a conversation with your tribes and for tribal leaders, making it very clear to your legal counsel how you would like those memos to go. For example, because we may be related to the child, and that would put your tribal leader in a certain capacity of whether they need to disclose, do they need to recuse whenever we have those conversations and any decision for that ICWA case. So just ensuring that you talk to them, would they like the names redacted? And moving forward in that way, or do they want to disclose the names so that way they can't recuse? So just simple things such as that. The other thing that I would say too is some tribal leaders want to be in the courtroom and making sure that you are providing all the information necessary for tribal leaders to attend. Although you are our legal representatives, it's still a part of our responsibility as tribal leaders to ensure the health, safety, and general welfare of our members. So please ensure that you're not excluding any tribal council member who would like to attend. The other thing, and I know it gets hard, even for myself when I was practicing, is remembering that although your opinion is definitely needed and warranted, it is your opinion, but it is tribal council or the tribe who needs to make the decision. Sometimes I think that line gets a little blurred, and just knowing that it's not an offense to you if your opinion is not fully taken. Again, tribal council has a lot of different hats that we have to wear and other different considerations that maybe your legal opinion didn't take into account. So just always remembering that it's not a personal attack on you. It's just tribal council needs to wear other hats and decided to go into a different direction. I think would be helpful. For any in-house attorneys that are on there, some concerns that have also come up are, when do you have the authority to utilize outside counsel? Because when you think about it, you're utilizing tribal funds to do that, most likely, whether it's through a grant or a general fund. So ensuring that you understand when, yes, you have the authority to say, okay, we're going to use X, Y, and Z law firm to cover that. Oftentimes I'm seeing that some people are just taking it upon themselves to use tribal funds. So just making sure that you're not getting caught up in that, but that you are, whether it's by resolution or by motion, that tribal council has authorized you to have that authority, I think would be very helpful. Those are just some of the things that I've seen in my limited time here as a tribal leader, that I would just ask that you kind of stop and think, like, should I be doing this? And for tribal leaders to ensure that you're having that conversation with your legal counsel as well, as to see what exactly is their authority, and basically when they step out of line, hopefully nobody does, but what are the repercussions for that too? I think would be very helpful.
I just wanted to kind of add to a couple of things Chairwoman Bill said. One is about going to court. Sometimes I found it hopefully even effective to bring people into state court hearings involving tribal children, because I think that's a show, or a display rather, of interest, the tribe's interest in the case. And believe it or not, there are still some attorneys out there, even county counsel, who don't seem to know what to do with a tribal attorney when we show up into court, like, oh, are you going to transfer the case? I'm like, oh, I just want to know what's going on and get back to my client. But there are also times, though, where I've been a tribal court judge where I thought it was appropriate to limit attendance in proceedings, child welfare proceedings. And the reason for that is because, number one, they're still confidential. But number two, if you put 10 people in a room, they might have 11 opinions about different things, and we have to be careful not to lose sight of what we're there to do. Okay. The other thing I wanted to add is that as a tribal attorney, unless I'm told otherwise, it's my routine and practice to email all tribal council members all updates on everything, and they can opt out. They can recuse themselves if they are in fact related or feel like they want to step away from a particular case for whatever the reason. But as a tribal court judge, I like Chairman Smith, but I don't want to email him, and I don't want him emailing me unless it's something about the general operations of the court or a grant, because I don't want to be accused of impropriety or anything like that. And the system works, but I think it has to work, or it works best when everybody follows that system.
Thank you. I appreciate it. I'm learning and kind of getting the wheels turning a little bit. I want to turn it over to folks here. But before I do that, I'm going to ask, I'm going to ask everybody, maybe folks have an idea on this. point made about disclosing names, for example. Do you exclude a name? Do you not exclude a name? From a practice perspective, in state court, when you have a dependency case, an ICWA case, we use generally children's initials, in re AG, in re AP. Now, in a small tribal community, just using initials, people can sometimes, or first name, so it might be John X or, Marigold Y. Especially with unique names, right? So in a situation where where a child has a name that would be very unique to that family or very unique to that tribe, that doesn't work. And so how to handle that? So I'm actually asking, in my experience in tribal court, it has always been to use the two initials. I've never seen anything different than that. But there's just not that many people in a small tribe, let's say, that have the last name that starts with the letter X, or the last name is, not a common letter. And so we had some discussion back and forth about whether we should change that practice. And quite honestly, it became a concern that you kind of, you could use the case number only, right? But that can become a little bit laborious, a little bit difficult. So I'm curious from a practice perspective, and Mark, I'm going to start with you as a tribal court judge. Do you have an opinion on that balance of privacy versus the balance of court operations, we'll say?
Thank you, Kimberly. It's a really good question. So, we're on the tribal court judge. They are small communities. They're smaller tribes in terms of their populations. And, I believe that we don't actually use initials. We use names, but we're very protective of our documents. What we do when we have to disseminate information that might be seen by someone who's outside of tribal social services or not a member of council is we do use the case number. And, to kind of piggyback on the presentation in this room immediately before this one about BIA tribal court funding, one of the recommendations that the Paula Tribal Court got last year, I think, was to post a notice of hearings on our court days. So we use just court numbers, case numbers for that purpose. But we do try very hard to protect identities. It's a little difficult though, when, as Chairman Smith noted, Paula is very actively hearing cases related to child support. So it has to go, my orders have to go to the tribe's finance department, to kind of deduct a child support obligation from a per capita check. So we can protect the child's identity, but not so much the parent's identity. And it's often easy to kind of figure that out. But it really has to be on the honor system. The respect for confidentiality can't be limited to the tribal court. It has to include the tribal council. It has to include the various departments of the tribe, because this is really sensitive information.
For us, whenever we would deliberate, and I think most tribal leaders that I've talked to about this, we also use initials unless we're actually voting, because a vote would cause, if we needed to recuse or disclose. So we would be actually putting our fellow tribal council member in their own ethical violation. So if it has to be voted upon, then we just goes to me. Just for tribal council, and of course maintain confidentiality.
And so question, in that situation, I know obviously different tribes, their governance requires different levels of public disclosure. So if the tribal council is deliberating on a matter in which you want confidentiality or some measure of confidentiality, but you have a contrary requirement that you have transparency with tribal members, you could see where you could find yourself running into difficulty. And then I hadn't even thought about the fact that an internal department within the tribe needs to know who they're going to be going after for the child support. So you've got to have a name and associated. So my only kind of practice point on that is have a rule, have it in writing, and train to it. So that this isn't on a case by case basis, so that you have parity and treatment of every single case. And that is, I think, really, really hard in these unique cases with unique tribes, is to say we're going to try and have processes and procedure that create parity across, because it feels like everyone is so unique, right? But it is a safety valve for everyone involved, for that tribal council member to say, we follow the process and the procedure. For the attorney, for the judge, follow the process procedure, and everybody knew it and it was public. And I worked for a tribe that did not make all of its ordinances public. So that created another, kind of catch-22. If I, for example, had to walk into state court and say X, and I had state court judges saying, can you show me the authority for that? No, Your Honor, I can't. And so to make sure that you've got really good articulated policies and procedures that give some protection from those ethical landmines, I think is super, super important. Yeah.
And just to that issue about the confidentiality of child welfare records, it's important for if you're representing a tribe, for your client to understand that by state law, you have to maintain the confidentiality of the reports and everything that you might be providing them. And so if you are providing them with the reports, they need to have a system for storing those files and documents separately from anything else, and a lock system and confidential access. So what I do, I have a long-standing client, I do all their work for the tribe. I no longer provide them with any court reports or minute orders or anything. I summarize in the memo to them with initials. I don't use the parents' names, I don't use the children's names. And they typically will know which families within this relatively small tribe are in crisis, so they'll typically know who they are. But the reason I'm doing this is not so much they won't know. So if those documents are printed out that I'm emailing them and left somewhere, they'll still be.
Joanne, that's a really good point. I'm going to repeat it for the folks that are online. So Joanne's point was that if you are serving as legal counsel, and quite honestly, this could go to social workers as well. It could go to anybody who has access to those California state or out of state, but state documents, those are confidential documents, but you need to provide information to your client. So Joanne's way of dealing with that is that she does a summarizing memo. So she's not handing the actual court report to the client. And what that does is saves the client the burden of then having to be, super hyper attentive. And quite honestly, I mean, I have seen, when tribal councils get together and they have a binder of all the materials they have to review for that day. And one tribal council member leaves early and I forget to grab their binder from them before they leave the meeting. Or, it's a multitude of ways, no matter how difficult or how vigilant you are. And then in the universe of remote appearances, it makes it even more difficult. So the idea, make sure that your client has a locked facility, understands the sensitivity of those reports, has a shredder if they need to shred, understands, we often have a mindset of we're required to maintain documents for some period of time, but those reports actually, there is not a legal requirement that they be maintained and they can be destroyed immediately. So I'm going on a little bit more than your answer, but I really like that kind of practice tip of summarize it, so you're not distributing the kind of state law protected document, and then also creates a level of ability to say, take out some information. I mean, certainly, I sometimes put my HIPAA hat on, think about what should, both in storage and also, I have had court reports that have disclosed, for example, illnesses that I don't think should be disclosed to anybody else. I'm sometimes surprised that counties have put reference to that. I understand for purposes of active efforts, you need to know that somebody, for example, is HIV positive or has a significant mental health issue. I get it, but not always necessary to have that go any farther than in that court report. So very much appreciate it. Yeah, Jack.
Question. How does that dovetail with the
And I'm going to talk to you about where to use it.
tribe?
So first of all, we know that young people make poor decisions. And as Raji talked about, it has a lot to do with the parts of the brain that are activated and the parts that are not activated. So in this picture, you see two people drag racing and you see two people about to jump off a roof into a pool. And those are the kinds of things that 18, 19-year-old boys do. 13-year-old boys, whenever you have a 10.851 case, you want to remind the court.
Okay, I think we got it. Thank you, Michelle. Sorry. Jack, could you repeat that? Sorry about that.
And the question was that, active efforts requires the state to be working with the tribe, collaborating with the tribe. The tribe has various things to do to help find a family, do all those different things. So how is what you're describing sort of jive with that? And that's the first part of the question. The second part of the question is, I presume that sometimes, well, I document sometimes we're directly social worker to social worker and not sort of everything through the attorney wants to try this.
And in my particular circumstance, I report to the tribal council, but there's a family services for the tribal director, and she gets more direct.
So the question was, Jack was asking, kind of how do you intersect or how do you overlay active efforts necessarily? And then also sometimes information will travel from a state social worker to a tribal social worker without an intervening attorney saying, whoa, hey, hold on a second. Joanne's answer was that it's kind of triangulated, it sounds like, in her practice, which is how that's handled. But excellent question. And I don't know that there's a perfect answer all the time for that. And so in my case, I would pick up the phone. That would probably be.
I don't limit the social services, tribal social service workers ability to communicate, worker to worker.
Yeah.
Across the state.
Absolutely, absolutely. And that can be tricky sometimes, right? When it's tempting sometimes to utilize your social worker and talk to the state social worker and not talk to county council, and how do we make sure that we're being, as Mark pointed out, really careful about kind of who we talk to and being protective of the attorney-client relationship for someone else, because we have a mutual responsibility to operate very ethically in that realm. And sometimes our clients don't understand that or get that. And, you might hear something and be like, I'll call county council and have that conversation with county council. We have run out of time. I want to say thank you very much. Maybe we could field one more question and then we will sign off. Okay. I don't see any additional questions, so I just want to say thank you. It's, one of the things about coming to a conference like this is it's a rare opportunity for us to be in conversation about these things that we don't often get an opportunity to be in conversation about. So really appreciate Chairwoman Bill and Mark sitting here and just sharing their insights so that we all gather all of the experience and all of the, the multitude of years and decades, Joanne? Yeah. In this room, it's really helpful and really beneficial for us all to have that kind of mutual learning opportunity. So just want to thank you very much. And thanks for folks online.